Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, everybody. I would love to test something that I think is gonna work. Portals! Portals! Fuck, that looks good. Can I put whatever I want up here? I can put whatever I want up here. Nigel's got a question. Who's buying the first round? You also asked a good question earlier, Nigel. I don't think that it shows up as OnlyFans, but I don't know. I don't know. So I'll have to check. Oh, look, it goes away in a minute. Oh, I'm so thankful. Look at that. Look at that. Showing up with some emojis. Oh, thank you. Oh, I love this. I'm so happy I spent some time today learning this. I hope everybody's doing well today. Where did you go to eat, Vince? Tell us where you went to eat. I'm so excited to be able to, or somebody could just look up what OnlyFans bills as. Just Google that. Maybe not Nigel. Depending, I don't know. A French bistro. Delightful. It's delightful. Okay. We have a lot of court to watch today, and we are going to, I love this. Cleave, it should say hostess, but I still haven't figured out all of the, I haven't amalgamated all my tech services yet. Okay, so what was I saying? Oh, we're watching a lot of court. I've got it in a folder. The folder's called Lineup. We're gonna watch a bunch. What was on the So should we start with Komet's? Yeah, we're gonna start with Judge Komet's dealing with some contempt. Sorry, contempt. So let's switch over. Let's see if. Oh, let's.
Contempt against
That's
Ms.
right,
Coleman
Judge, I
for
already
not
said that.
complying with current court orders. The current court order is to have FaceTime every Sunday at 10:30 and Wednesday at 6:30. Ms. Judy, is there anything you have to add to this? I believe we have several complaints. How many total?
We do. I've counted 10 total. Both
Okay.
the complaints I sent over with scheduling this meeting, and then a few that we received after scheduling the meeting as well.
All right. How long are these calls? Because there's no specification in the court order.
That's correct, Your Honor. Nothing that's specified within the order itself as to how long the calls need to take place.
All right. Mr. Coleman, how long do the calls generally last? We're dealing with almost a 5-year-old.
God, look at that. I beat you, Streamlabs. You do your job so terribly that I have to do it. Thank you so much, Christopher Engelby. Oh, get back up there. Thank you. I said get. Oh, clicking in the wrong thing. Get back up there. Look at that. It's got super chat all highlighted. Thank you so much, Christopher Engelby. Your sound will be coming soon. Thank you so much. That's awesome. I'm very happy that we can do both. Yes, it's absolute fire. This heart is on fire. Let's watch the case, Paisley.
Typically, when I have his attention, around 5 minutes.
I was going to say normally it lasts about a minute per year, and we're technically at his 5th year. So, yeah, normally about 5 minutes is as much as they can contain. No offense, it's just a rule of thumb that always seems to work, a minute for every year of age because their attention span. Once they hit about 9 or 10, you can double it, but you got to wait until they're
Yeah,
in school to really start getting their attention span. All
yeah.
right, ma'am, your response was basically that he is threatening you, correct?
It's harassment and verbal abuse, yes.
And when is this harassment and verbal abuse allegedly happening?
Um, any day. Um,
Are they during these parenting time exchanges?
they're not.
Okay. Sir, how often do you try to contact the mother?
Typically, when the calls were missed, I would text her about it.
Okay.
And then also when we're having the calls, I've been having a lot of issues with distractions being in place. So
Well,
I tried to.
we're dealing with a 4.5-year-old. You're talking about, heck, I have the memory
I
of a
mean, yeah,
gnat and the
you're
attention
right.
span of a squirrel, but
I mean, I get that and I understand that, but when you add an iPad into the play, a TV into play,
all right. Then what we're going to add to what we're going to
traveling
add,
into play.
because I'm definitely giving you makeup time. And how I'm going to do that is we're going to increase these to 3 calls a week. Does Miss Coleman, do you take the child to church on Sundays?
I do not.
Okay, the reason I'm asking is because 10:30 on a Sunday morning, it could be a problem for some people, but for most people anymore who don't go to church anymore, not that big of a problem. So I would leave it at 10:30 on Sundays and then 6:30 on, and I take it you're out of work at 5, ma'am?
I do not currently work, no.
Okay, then 6:30 should work on Tuesdays and Thursdays.
Mhm.
What I would ask that you do, and part of this order is no other distractions. Turn off everything but the communication device. All right.
Um,
The call should last for 5 minutes. You are in contempt of this court because
okay,
you are not violating court order. This comes with an instruction to both of you because there was some things in here about your family also harassing her, Mr. Coleman. That is also a violation of a statute. It's called the inherent rights of the child. Neither party is allowed to disparage the other party at all, nor to allow any third party to disparage them. So this is a warning to you. Curtail it. All right. There are no calls to her or communication outside of these calls for the child. The way you do this is to hold her in contempt. Ma'am, I'm going to hold in abeyance any fines on this. But you got to understand, if you don't start doing it, it's going to be a fine of $25 to $100 each time.
yes, Judge.
It increases each time there is a problem. And I realize I will give some leeway to the fact that we're dealing with a 5-year-old. Mr. Coleman, it's my understanding you're in the military, correct?
I'm not anymore. And
Not
that's,
anymore. Okay. Are you staying
yeah,
in wherever you're living?
yes.
Okay. Because, ma'am, you got to take into account the fact that the court's never going to jump to he can threaten to get joint physical custody or take custody from you. That's not going to happen absent very extreme circumstances, like Child Protective Services getting involved in removing the kid from you. Protective Services gets involved every once in a while, but they don't remove the child. And it's like they go to check on something. That's not going to create a change of custody. Sir, if those are the kind of things you're saying, stop, because it's obvious that if you do continue that, she can record the conversation in Michigan. Not the conversation of the child, but she can record a conversation that you have with her. And if she does and she shows
You're teetering on legal advice here, Judge. You're teetering. You are teetering. I don't know if they're meant to be, if you're meant to do that or not. It's not really funny, right? Hey, Casey Carey, thank you so much. Oh look, I can like it from here too. Look at that. Super chat. I really like how it says that at the bottom. Super chat. Thank you. MB. MB. MB from hot as hell, Texas. I saw your PayPal. Thank you so much. I love you too. When is the sound coming? Streamlabs. Streamlabs. I can't believe I've had to take over most of Streamlabs' jobs already, including thanking people for super chats, putting up my own chats, and then he just, or she, just strolls in belatedly here. How long is it gonna take? Also, Pokeroo, were you asking if I live where I stay or the people on the screen? There we go. Yay! Thank you so much.
Shows the court that you are doing that, that might prevent your parenting time. And you have to also understand the reasonable consequences of making any kind of harassment to her. Of course, she's going to back off. That's why I'm not charging her any fines right now.
Well,
You
I'm
know,
not
because-
harassing her, sir. And I
Well,
have messages, emails, and
if
proof
you're
of
saying
that, so.
if you're saying something, what I'm saying is, if you're saying something like that, that can also interfere with your ability to increase parenting time or change parenting time or do something more. Like I said,
understand that.
this is a warning because most people don't.
This is a warning. Vince, sometimes it is not me, it's YouTube Daddy. YouTube Daddy prevents some chats from going through all the way. I specifically don't have those types of filters on here, so everything should go through. There is a way to prevent it from being shown up on the screen. And Pokeroo, thank you for pointing that out. It's quite obvious, is what the bottom says. No, I know. I just like to point it out. They all are, Kevin, in one way or another. I got balls and boobs on the screen. Right, Denali Mike? Okay. But we have parents doing bad things. And owls doing owl things. It looks like it's cutting it off on purpose. That's funny. I still haven't perfected the chat highlight situation. Boob shaking. Ah, Chris. Oh, I can't click on that. Yes, I can. Oh, it says gift. Fuck yeah. Yay! First of all, that's great news that Chris can give. Thank you, Chris, for giving. Second of all, how fucking cool is that? Why does it cut off the bottom? I'm gonna have to bump that down. But that's awesome. I love how it's it's like shiny at the bottom. I am crazy. Ooh, me? Anyways, is there there shouldn't be low resolution. At least 720. That's what I got. Well, I think I should have 10. Whatever. We're doing 720.
Don't know the law. You're presumed to. But if I can explain it to you, it generally changes the way you interact with one another. When you do communicate with each other, sir, you're talking to the mother of your child. Ma'am, you're talking to the father of your child. You're not talking to each other's ex. All right? Please understand that that child inherently, they've got big ears. They'll hear things two rooms away. You know, let's face it, they don't pay attention to any parent, and all of a sudden you say something you don't want them to hear, and the next thing you know, what was that? And they pop up around the corner. Come on. Children are the biggest con artists and manipulators in the world. I think they were designed that way. It helps them to survive. That's why God made them so cute.
Nobody was laughing at that one, Judge. That came across very creepy, in fact. Hi, Navar, by the way. I don't know. I don't watch that court. I didn't watch that court. Yeah, nobody laughed at that one. That was just like, did you just say that about our child? Our 4-year-old child, that they're manipulative and evil? Even he knows. Even the face on him is like, what is on his tie? I choose to believe that it is octopuses? Did you hear that motorcycle? Please tell me somebody can hear that. Right? You heard that? Please. Probably not. Anyway, so loud. Oh, you hear the bike. Okay, good. Octopies? Or a Pac-Man in movement? I thought it was a Pac-Man in movement. Sounds like a scooter. No, Kevin, I'm on BC time. I'm on the West Coast on Vancouver Island. He'll be bigger in a minute. We'll get a peek in a minute. Ew, Kevin's got it right. He knows that it's a sick, humble brag that I live on Vancouver Island. Don't worry, Kevin. I don't want to live here. I'm stuck.
Okay. And I have no doubt that both of you love this child. And we really need to get the communication going more frequently as well, ma'am. So the inherent makeup time is I'm increasing the time, but it's going to stay increased afterwards. So after all the time's made up, sir, it stays at 3 times a week. Sunday at 10:30, Tuesday and Thursday. If either of you need to change that, then you may file the appropriate motion. Okay. But the court
It
order would
was
have to
at
change.
2 times, so now we're increasing
Yeah, I
it
know.
to
You're going to 3, so because I
Okay.
need to make up 10 times that he missed.
Okay.
But what I'm saying is after those 10 times are made up over the next 10 weeks,
Mhm.
I'm leaving it at 3 times because I want this child to have continuous contact. It's only 5 minutes. And like I said, I want in the order that it's, a minute for every year of age. And right now he's 4.5, so 5's close enough.
Per
And
my
then we may
phone-
increase it as he gets older. What, ma'am?
Okay. Per my phone documents, these calls last around 30 seconds.
Try and see if you can get him to pay attention. Like I said, turn off all the distractions. And Mr. Coleman, please understand, if you've got a 5-year-old that's going, yeah, I'm bored now. Now, I'm not going to hold her in contempt for not making a 5-minute call when it's the child's attention span.
Completely understand that. My biggest issue with the calls is not that. It's more so the structure of the calls to this point. Is like you said, when you put TV in play.
Well, that's why I'm ordering that no other devices be on in the room where the child is talking with you.
I just want to set record that that's not what's happening every single phone call.
Well, I understand. I'm just making sure
Okay.
that I'm trying to eliminate any problems here.
Okay.
It'd be nice if it would be nice, when I speak to kids, because I generally have to speak to children in custody and parenting time cases, I tend to speak with them in their room. And sometimes the younger, unfortunately, the Supreme Court has said that we've got to meet with kids under all the way down to 6.
Judge, you gotta be careful. That is very, very, very close to being fucking weird, and I would you gotta be careful. Also, yes, Kevin. So Kevin has written, for those that don't know, BC Vancouver Island is ew for one of 3 reasons: North Island, crime, and white trash. That's true, allegedly. Mid Island, hippies. Yeah. Although I would say a white trash too. And then South Island, very expensive, old people. Yes. I have lived here my whole entire life, Kevin, so I unfortunately come by it naturally. But I wasn't born here. So that just makes me a little extra Canadian. Immigration, right? I want to, Courtney. I want to, and we do. We do. And you know what, Kevin? I luckily, I can't, Navar. I don't know how. I've just learned how to do this, and I'm doing it in a special way. So write shorter comments. It literally, if I raise it up, it won't be there. I wish it was, but it's not. It's a setting that I worked on, but I decided, you know what, we'll just go forth with what we have. Alberta is called Canada's Texas. That's true. It is. We're almost there. I played with it for quite a while. Anyways, let's pit play.
A little sketchy on that, but all of a sudden I get a 6-year-old showing me their favorite toy. But if he's in the bedroom, those are things, Mr. Coleman, that you can ask, what you got going on in your room, because let's face it, he's going to be up and down, off the bed, down on the floor. And what type of device does he use to communicate, Ms. Coleman?
My phone, my iPhone.
Okay, so it's easily handleable in his hand.
Mhm.
Okay, so he can carry it with him.
Mhm.
Yeah, I will tell you, I was terrified. My daughter's 20, almost 24 now. When she was 9, I saw her carrying her phone around in front of her face, and she's 9. She had just gotten the phone so that we could track her. You got the GPS on it. It's a really nice thing, actually. But she's walking around and talking to it. And I'm like, what are you doing? And she's like talking to Grandpa and showing him around the house. And I'm like, wait a minute. What scared me was the fact that I had no idea how to use FaceTime. I didn't even know what FaceTime was. And my 80-year-old father and my 9-year-old daughter knew how to use it.
It's COVID babies.
Well, this was before COVID. Like I said, she's 24. This was 15 years ago. And I'm like, okay, this is another part of the sandwich generation. You got the older people that are getting tech savvy because that's their ways of communication and contact with the world. And you got the younger ones doing the same thing, where the rest of us are all working a lot. Trying to keep.
Judge, I do have a question.
What? Can somebody boomer translate for me in the chat? No offense to anybody in the chat that's a boomer. I know you're not all like this, but I've never heard of somebody more like that's so ridiculous. These young kids and these old people are always doing things that bother me. It's like, what the fuck? Get off my lawn. Stop cutting down my trees. I want to complain about them.
Sure.
What do I do if the phone calls don't last 5 minutes and
try and leave the
Okay.
child with the phone for that 5 minutes.
okay.
If not, the kid may dump the phone on the floor. Record that, basically just make a note of it. Child walked out of the room, dropped the phone, and that may happen. Kid goes, Daddy, I'm going to go get a juice. Done. Like I said, with 5-year-olds in long distances, we have problems. But that's why sometimes increasing the contact is what helps. It's not perfect. None of this is. I'm just trying to do what's best so this child knows his father. Let's face it, I didn't set this situation up. You guys have. I'm just trying to do the best I can for you within the constraints of the law. All right. Just don't stop the phone contact. You don't have to contact, any messages he sends you or something, ma'am, keep copies of it. If it winds up to the level of harassment, filing a personal protection order is in order. And that's the warning to Mr. Coleman too. Be very careful of that. Okay. Ma'am, you need to contact him and tell him when's the child starting school.
September 11th, and he knows that already.
Okay. Sir, you contact the school. You have the right to have access to the school portal. All right. They will give you a password and everything. Well,
Portal. Seriously, portal. Do we have a command for portal? We must, right? Do we? A portal. This is marijuana. THC shatter metal rules. And what is the brand? Well, the brand is Fido. The type is Ice Rack Shatter. And this is where I keep it. Also, Paul, school to me starts in the first to second week of September. So, first week if you're unlucky, second week if you're really lucky. And that is, I thought we had a portal. Oh, there we go. I want a portal. Daddy, I want a portal now! If you don't know what we're talking about, we dealt with a few cases a couple weeks ago that dealt with an online portal game. It was hard to follow, to be honest with you. It was hard to follow. But we don't end school, keep in mind. We don't end school until the end of June. So I think you guys have earlier summer because maybe the temperature, I've always surmised it was the temperature. Mayor! Guess what, Mayor? I can put you up on the screen here. Hold on 1 second. Give me a gosh darn minute, if you would. Give me just 1 minute. maybe more than 1 minute. 2 minutes. Give me 2 minutes. I'll put you up on the screen. There. Look at that. I love it. Can't get enough of it. But yeah, so that's the joke we're making about that. And these people, can you believe they fucked? That's what I always forget. Like, these two had sex at least once. You know, at least. No. Moose time, right? Oh God, you guys are hilarious. And you know what, Metal Rules? We're okay with not sharing these days, but we like to hear what you're imbibing with, but we understand the not sharing. But it's the thought that counts.
I think you have to make up your password, but they will give you access to the school portal. You have that right. And you have the right to contact the school and talk to the teacher. Okay? That's both parents' rights, so that both of you know that you have the ability to have that contact. So feel free. The good thing about the internet too and stuff like this is you can contact the school no matter what state you're in. All right. So, and she can't limit that contact. Now, if you harass this, if you're a problem with the school, they can limit the contact. So please be careful. I've had people not do the smartest thing in the world. So forgive me if I'm jumping to places that I don't know if either one of you would go to, and I hope neither one of you will. I'm just trying to give you the parameters. Because no offense to you, I'd love you to raise your own child, and I'd love to not see you with all that often. I'm here if you need me. Okay? Because this, eventually we'll see what happens, and things need to be reassessed in the future. Parenting time is always reassessable until the child's 18. All right?
Yes,
So
Judge.
we'll see what happens. All right. Both of you take care. Miss Judy will draft the order of the court. We're going to try and get it to copies to you as soon as possible. Today is Wednesday. Did you want to start with having time tonight, or do you want to start tomorrow night, Mr. Coleman, and go with the Sunday, Tuesday, and Thursday beginning immediately?
I have something going on today, so
Okay.
start it next week would be preferred.
Okay, start it on Sunday, and then Tuesday and Thursday next week. No problem. Take care to both of you. It was nice meeting you. I hope things go better in your future. Sometimes just an explanation is enough. All righty?
Yeah.
Take
Thank
care
you.
of yourselves. Enjoy the first day of school.
Yeah.
I'm not going to hold her in contempt, sir, for sending you a picture of the child's first day at school picture. Some communication is appropriate between the two of you. I'm just asking you to be cautious. All right. We have formats and platforms that are available to have you communicate, like My Family Wizard or other things like that.
Part of me actually wonders if the judges and lawyers say it wrong because they want to be paid to say it correctly, which would be smart, right? We should call it My Family Wizard until in fact it is Our Family Wizard, hashtag not a sponsor yet, but open to it any day of the week, Our Family Wizard. I have a brilliant marketing plan for you. But I just laugh every time. These judges are putting it in their orders and they don't even know what it's called. I knocked something over. Yes, My Family Lizard also. Let's see. Okay, let's see what happens with Mikey's check mark. Oh, that's funny. I like Harry Potter. Look. Verified! It says verified, Mikey. Wow. I mean, it's pretty epic. That's pretty epic. You don't say everything wrong, do you? It's a cute check mark that they turned into verified. Hi, how are you? We're having a good night. We're just getting started. Judge is at cringe level 7.9, was it? 7.9. I am so proud of Mikey for getting that check mark, though. Seriously, it's obviously life goals. I'm just so proud of being able to have set this up, too. And my boobs look good today. YouTube is... No, they don't sell them. In fact, you have to have a YouTube manager. One day, when I make it, I'll have a YouTube manager like Mikey. Okay, let's continue with the cringe and the comments.
That, and if you ever need that, then feel free to call. But yeah, normally texts and emails are savable and printable, which means sometimes that's the best format to contact, and you contact if there is any contact outside of these calls because of something that's happening with the child. I would expect her to contact you if the child is, gone to the emergency room or something like that. Or like I said, maybe send you a picture of the first day at school. All right. Good luck to both of you. Take care.
Thank
Take
you.
care of your child. All righty.
Thanks.
Thank you, Miss Judy. Miss Judy, I'll let you put on the record what's going on briefly.
Yes, Your Honor.
Okay, before we begin with this case, so this is a new case, and, hold on, let me get my proper chat thing up. It takes a second. Also, Vince, I really liked your joke about recommended by 8 out of 10 dysfunctional families and their judges alike. Oh, look at this. How does this show up? It's not highlighted. Oh! Now it doesn't say verified. Maybe it was just telling me one time. And it's like, no. That's so funny. Wait. Yeah, it didn't do it. But wait, did this one? I didn't imagine that. I talked about it. Now it's gone. What the fuck? Just one time. Nope, it's back. Okay. I don't understand. Let's just hit play, Pace. Just hit the play button. Courtney.
The parties are parents to one minor child, this 1-year-old XEHV, if we're going with initials today. The temporary order is dated 5/13 of 2024, indicates that parents have joint legal and joint physical custody, with exchanges to take place on Fridays for week on, week off custodial time. We're here today regarding alleged violations of the court order filed with friend of the court by Mr. Huerta against Ms. Villa Bravo. Again, friend of the court received custody time complaints for the dates of Friday, May 24 of 2024 and Friday, July 5th, 2024, where he indicates he went to the other parent's home and Ms. Villa Bravo denied him his parenting time.
All right, so we only have 2 complaints.
That's all that we received.
Okay, Mr. Huerta, have you been receiving the child other than that?
No, not yet. Any
Okay.
I ran out of papers to fill out, but
Okay.
yeah, still
All right.
nothing.
Well, Miss Villa Bravo, what's the explanation here?
So I feel like my kid is not safe with him. He is a drug addict and an alcoholic, and he has been dealing with problems since I first met him, which was 2
Okay.
years ago.
I have a question. Do you have a copy of the order?
No, I don't. I never received a copy of the order.
All right, Miss Judy, did you send her a copy of the order by chance?
Our office did not send a copy of the order outside of the motion paperwork we sent for this hearing today. It would have been involved in that paperwork.
Okay, so you have a copy of the order now, Miss Villa Bravo?
Yes, now I do. I received
Wait,
the motion
all right.
for this court.
Okay, here's the problem that the court has. Miss Villa Bravo, I take it I notice your address is confidential, but you no longer live on Chicago Drive?
I do live on Chicago Drive. That's my permanent residence right now.
Okay, then why are we making it confidential if it's always been known? That's where this case was filed.
I don't know. I never put confidential
Okay.
anything.
Well, oddly enough, the court received, the reason that I asked the question is because that's the address the court has you at. That's the address this order was sent to, and it was returned by the post office.
Yeah, I've been living in that address since November of 2024.
So this should not have been returned by the post office, but it was. I'm
Okay,
alerting
yeah,
you
I
to that.
never received
I'm alerting
that
you to that
first
issue.
one.
What I'm doing this for is to say that the court has evidence in the court file itself that she has not gotten a copy of this order, which means, sir, that I cannot hold her in contempt when she did not receive an actual copy. Under due process, the court can only hold someone in contempt for an order they actually have actual knowledge of and its contents. So just because you know a court order exists does not mean you can be held in contempt for compliance because you don't know what the terms of the order are.
Yes,
Now she
correct.
does know. So she can be held in contempt from this day forward. The other problem that I have is, ma'am, you were not at the hearing that granted this order, but you were there that morning. According to the record, you were present by Zoom, and you got to understand, on Friday mornings, we do 15 to 40 of these on a Friday. So it's first come, first serve. In Kent County, that means you get heard every 2 weeks. Surrounding counties, if you file a motion, they will call you back and say, I'll see you on November 6th at 10. So in other words, we do it cattle call, but you get heard every 2 weeks. All right. So there is a waiting because of how many we do, because we don't control how many get filed. Everybody files the motions that need to be filed. All right. But you don't just take off. You need to be at the hearing because you left, which means the court didn't hear from you, didn't hear any of your concerns. None of those concerns are in the file. So if you want to change this order, you need to file a motion.
Okay.
All right. But until such time, you're under warning that this order will be enforced because the judge issued it.
Okay.
I cannot
So-
hold you in contempt for these. Sir, I wish I could help you at this point, but you got an order that is basically an ex parte order.
Okay.
And, the other side was not able to be heard, so we don't know what the circumstances are for this child. Orders are issued on behalf of the best interest of a child, not on behalf of the best interest of a parent. But you did get the order. I apologize. I apologize for the mix-up here. I don't know what happened with the post office because that is the address specifically listed on that envelope. But it was returned to the court, and always both of you maintain any address changes in writing with the friend of the court and the court. Okay, so that can be placed in the court file. I don't know why it didn't get to you, ma'am, but because of some odd fluke, I cannot hold you officially.
I tried going to get it and they were not letting me get it.
Well, now you have a copy of it, so you need to follow it, and or you need to file a motion to either abrogate it or change it.
Okay.
All righty. And I believe that we will be meeting each other soon for a settlement conference. All right.
Okay.
We'll see if you file a motion to change this and if that works or if the judge keeps it in place. All right.
Okay. What
But
would I
can't-
have to do? I just gonna have
You
to
did
wait for the
you did
phone.
everything. You did everything right. What you didn't know was that she didn't have a physical copy of the order.
So with moving forward, if I don't get my son this Friday, can I do?
Then like I said,
I do it?
I will hold her in contempt if she does not give you your son, because now
All
she
right.
officially knows it. All right.
All right. Sounds
Good
good.
luck. Good luck to all of
Yes.
you. I apologize about this is a fluke.
Yep. No,
Some days I cannot explain
Yeah,
what
you're fine.
happened. All righty.
All right. Yep.
Good luck to
thank
both
you.
of you. All righty.
Yep.
Bye.
Thank you. Bye.
Don't thank me on this one.
I won't thank you on this one. Also, whoever said that it was my booty call, you're wrong. It is not my booty call. It is my ex-boyfriend, who happens to be also my roommate, because I live inside of a cruel, cruel, cruel spin-off of my world where I live with my ex. And he called to complain about not being able to find an ice cream bar. I don't care. And I have to talk louder. I can't seem to turn up the mic. But I do appreciate all of your critiques because they're very helpful. And Mayor, you are. You absolutely are. Also, I did find out that it does say OnlyFans when you sign up for OnlyFans. So, there you go. Anyways, so what would you do for a Klondike bar? Apparently, he I don't even know what kind they are. I don't care. I'm like, I really don't give a fuck about this. I'm already his personal chef and make his meals for him. And so yeah, you're probably right, Kevin. It might help the boobs too. But I am trying not to And then I said I'm live, and he's like, oh yeah, you and nobody is sitting there watching you. I'm like, there are people here. Anyways, oh, I'm getting no ice cream. I'm trying not to eat ice cream. I have my fucking apples and peanut butter that I've had for dessert this week. And I did tell him to piss off Vicky, and he was like, oh, thanks. I was like, I gotta go. I'm fucking busy. I'm busy. We're watching court. God damn it. We have a new judge to watch. Real talk. Does he subscribe to my OnlyFans? Real talk. My ex-boyfriend does
All right,
not.
so my
I would
assumption
expect my
is that
current
with that
boyfriend
notice that
would.
we are up and
Definitely.
running, so
Wrong.
call the case.
Sure, Your Honor. Ron Pulaski with the Kent County in front of the court presenting Richard Boyd Kearns. Mr. Kearns has one case at our office. That docket number is 1996-008-193-DP. Richard Kearns versus Marie Tubergen. The case is actively charging at $611 per month for the support of his daughter, who's not due to be emancipated until 2027. He currently has an outstanding arrears balance on this case of $44,350. In regards to payments being received, last payments received were through an income withholding order. The last payment was November 28th of 2020 in the amount of $820. October of 2020, we did receive an income withholding order payment for $1,640. September of 2020, another payment for $1,230. And looks like July of 2020, he paid $800 through income withholding order. We've had 6 show cause hearings and 4 bench warrants on the case. There's been a total of 5 contempts on this case. And speaking with Mr. Kearns, he resides in Texas. He's been residing there for the last 7 years. He's staying there with his brother. He's able to pay his brother rent in the amount of $300 per month. He has the 2 children on this case, a high school education.
Actually, listen, I like the cooking part. The fact is he's on a boring diet right now, so it's even more boring. I hate cooking for just myself. But he is on a super boring diet right now, and Ozempic, which is just like it's just terrible. It's terrible for me as a chef. But apparently he's late on his shot or something because he's out hunting for fucking ice cream. And I'm laughing to myself like, I had an apple last night when I wanted dessert, bitch. But I don't take a shot that makes me lose weight like that. I wish. I sort of would if I could. Let's be realistic here. Anyways, this judge, we haven't seen her before. I like her scarf. It's sort of, oh, I just noticed it says KCCF. I take no responsibility. Oh, also Kevin, very diagnosed. ADHD as fuck. I think it is a command or 2 or 3 or 4. Yeah, there it is, right there. Oh, I did the medicated thing. I'm going unmedicated for a little while. I switch. It's fun like that. Really keeps your brain grasping for that serotonin and dopamine. So when you finally get it, it really feels good.
Doesn't own a vehicle, but drives his brother's work truck and works for his brother. He does have a Chime account and stated to me that he can possibly obtain funds in the amount of $1,200. He did serve 4 years in the military and the Army with an honorable discharge. He's not receiving any VA disability payments. He has no health, medical, or mental issues going on. There's no substance abuse issues going on. He's not on probation or parole. He has one prior felony, I believe he said 15 years ago, from the Attorney General's office here in Michigan for, again, failure to pay on this case. He informs me that he was arrested last month in Texas and was dealing with the extradition process of returning up here to Michigan. In regards to work, he did inform me that he works for his brother cleaning ice machines. He has a background history of doing heating and cooling work and subcontracting work. He did provide me a number to his brother. He is employed with his brother, and he did state that his brother could potentially get $1,200. And I believe that is all the information I have at this time. The last contact we had with him was back in February 2021. He did email our office indicating that he was working, that he had a couple of installation jobs and the payments would be on the way and that he'd start making routine payments. However, in 2021, 2022, 2023, and 2024, he
I know that's sort of funny, but I recall something about Legionnaire's disease being transmitted in ice machines. I'm pretty sure. Like in hotels, there was a really big outbreak of that. And because they did not clean it proper. And I believe that. If somebody looks that up, I believe that's probably correct. Again, I retain very odd information, but it is very important to clean all sort of water spigot spout dispensing areas. You know, I think, yeah, that's the way it be. Standing water does equal bad for sure. Nice. That's a good idea. Love it. I have shower content. I think. I don't think I have ice content. Now I'm going to be turned off of ice for a little while, but I'll get back there. I love ice. Oh.
he's not made any payments on this case, Your Honor. Thank you.
All right, thank you. Mr. Walker?
Yes, Your Honor. I did get a chance to speak with Richard and kind of go over some things. He is he did indicate that he can pay $1,200, but he's got to get out first to do that. It's money that's owed to him by his brother for work that he's conducted. He's willing to pay that as soon as he can get out. He does have good work to get to, and he is at risk of losing it because his brothers may have to hire somebody else if he can't get out. So he is hopeful that he can return, but he's got to get out of here to do that. He is willing to make payments. He does understand that he hasn't been making payments consistently, and he does want to avoid or get his payments down and avoid another felony charge and having worse sanctions here for this. So he is hopeful that he can do that. Those are his resources at this time. He really doesn't have much else. So I would ask the court to withhold the contempt citation today, allow him to get out and make that payment, and get started on a payment plan that would be beneficial. He did indicate that he could pay double the amount, $611, so that would be what, $1,244 or something like that. He could make those payments as soon as he gets out. He's willing to do that to make sure that these arrearages get paid down, and he steers clear of future sanctions, Your Honor.
All right, thank you. So, Mr. Kearns, now it's your opportunity. If you have some information that you think that the court should have at this time regarding the situation, now is your opportunity to do so.
Thank you, Your Honor. Pretty much with all the facts that you had just heard today, I could definitely double up on the payments that I have paid, and I know I haven't made any since 2020. After COVID, work was sporadic, to say the least. A lot of people didn't pay whenever we would work.
Legit though, MB, what you do is just take it and cut it up and then put some cornstarch on it, just a small amount of cornstarch. But basically, if your dose, if it was pre-dose, let's say it came in 100 milligrams, and you want each of them to be, you just cut it into equal bits, and then you should have, if it was mixed properly, you should have equal doses. Oh, look at Patrick. Thank you so much. I love that. Oh, It's just a little one. It says super chat. Patrick B. Thank you so much, Patrick. I really appreciate that. Streamlabs is going to come in and do its job here in about, I don't know, a minute and a half. But I'm saying thank you. Thank you.
So my business pretty much had failed. My brother kind of went a different route, just doing, cleaning machines, not really doing installations, things like that. So his business is doing great. And I had just started helping him, and I hope I can continue to do that. I'm going to speak with Marie, who I speak with pretty frequently about the girls, and I'm going to ask her if she would reduce some of the arrearage owed for some of the, and I know it's just gifts, for Christmases and birthdays and things like that. And I know that count, but
Oh, what is that? Is that the worst ringtone in the world? Is that a fire alarm? Is that a phone? Is that a jail alarm? It's like the beep of a smoke detector on crack. That is a fucking nightmare. What the hell is that? Oh my god! Oh, now I'm knocking things over. It's alarming me. I'm alarmed. Oh my god, that was jarring. Jesus Christ. Do we really think so? You guys think? No. Ew, brother, what's that? Brother, what? No, I did. Ew, brother. What's that, brother? What's that, brother? Evacuate! Kevin says evacuate! Ah! First of all, that was for Patrick. Thank you. Kevin says evacuate. Oh my god. I don't know what it means. Are they 12-volt batteries? I feel terrible for him. He looks like freaked out. I would be too. Thank you again so much, Kevin. I love how it does super chat. Oh, see, it looked like something else was below there. I'm gonna fix these settings tomorrow, and they're gonna be even better. Oh, you guys. Thank you. I'm really hoping that Kevin's thing, like Streamlabs, we have to have a talk. Like, this is a fast show. It's a fast-paced show, okay? And it's just like you're dragging the whole team down. And I don't want to have to talk to you about this in front of everybody, but it's embarrassing. I already said thank you, okay? We've talked about it twice, and you still haven't even popped it up. I'm not asking for a lot. I do it. Come on now.
But yes, ma'am, I'm going to ask her to do that, even if she doesn't. I'm responsible for all of the arrearage, and I apologize. I'm sure there's some weeks that I could have sent money that I didn't, and I apologize for that. But now I don't ever want to do this again. I'm 52 years old, and I don't want to be drugged up on a bus and get any more charges for this. I want it to go away. I want my child support to be paid down, and she turns 18 in a few years, and I want to be done with it. And that's pretty much the facts of it. I would like you to know, Your Honor.
All right. Thank you.
Given this opportunity, sorry.
So, Mr. Kearns, let me ask you a couple of questions then. So you have known of this obligation that you have to pay child support?
Oh, yes. Yes, ma'am.
And you also are aware of the fact that if you don't have the money, that you could submit 20 job searches in lieu of making a payment?
I honestly did not know that. As long as I'm looking for work, it would. And that's again my fault that I wasn't aware of that.
Yeah, you should have been told just about every time you came to court that if you don't have the means by which to make the payment, that 20 job searches in Michigan, 20 job searches are acceptable in lieu.
You hear that, kids? You're worth 20 job searches to the state of Michigan. And guess what else? 20 job searches is nothing. You can do that in fucking an hour. Okay? That's all you're worth. Can you believe that? I find that offensive. 20 job searches. They basically bank on somebody not being willing to do 20 job searches. Like, it's easier to get a job, I guess, in their mind. It's ridiculous. Ridiculous. Fucking pay your child support, dude. Thank you, Casey. Or Kevin, sorry. I see you say Casey. Okay, now I can't even read it. Why is it in the other... Oh, there we go. I am worth at least 25 job searches. That's right. You can't just do a fast food thing? Why doesn't it serve? It doesn't say... It does say that. I can't click it. Now it's bothering me, too. But anyways, you guys are great. Okay, but seriously, it's a bother because he's super out of it. He's super out of the game. Like, your kid costs money, bruh. Come on, bruh. Also, I always want them to know, like, how are they subsisting? Some judges ask, some don't.
Of that, but you have to continue to send them in.
Yes, ma'am.
If you are not able to make the payment, and that would prevent you from having then to appear like this and to be brought up on contempt charges.
Yes, ma'am.
Also, keeping in contact with friend of the court to let them know. So I noted the request at this time is to not find you in contempt, but it appears to me you've had a job on and off, maybe not consistently, but when you had those funds, you didn't send any this way, by way to friend of the court, nor did you do the job searches, but it sounds like you might have either forgotten or just didn't know that you could do that. But with respect to the employment piece, you did know you had this obligation and you didn't send anything. So I don't have a choice as far as contempt is concerned, but I do have a choice when it comes to whether or not I hold you. Now, it didn't sound like you really had the money in your account, that it sounded like you was waiting or counting on your brother to come up with the money that he owed you so that you could get out. Is that accurate?
No, ma'am, I spoke with him in the cell a while ago. He has the $1,200. He has the money he owes me. And when I spoke with Dina Smith, who is the head investigator, I told her that we had the $1,200 that we could send. He could send that today.
Okay, because the last thing I want to do is keep you in there on funds that you really don't have waiting on somebody else.
Yes, ma'am.
Because technically I have the ability, if you don't have it, any funds, that I can have you released, giving you the benefit of the doubt.
Yes, ma'am.
To be able to get the funds and then have it deposited with friend of the court by a certain time, if you thought that you could get those.
Yes, ma'am. Now, you may not have the 500. I went to court this morning and the judge had given me a $500.
Now, what the fuck are you talking about? Is it... You just said he has your $1,200 for you. And what's the $500 for? Is that a different charge? Also, how'd you get arrested in Michigan, buddy? Aren't you from Texas?
So, I mean, I could send the 1,200, but I wouldn't have the 500 to.
So you wouldn't be able to get out. So
Yes.
this is what I'm gonna do with respect to the warrant that we have. I'm gonna say that the amount that you will owe for release is the 1,200, since that's what you indicate your brother can do.
Yes, ma'am.
So then upon payment of that, we won't be holding you any longer on this matter. You may still be held on the other bond if you can't make that, but at least for this portion, you won't be held on that. However, you know of the obligation. If you are unable to make the payment, you have now been reminded that you can send in 20 job searches and that counts as your payment. But you have to continue to do that. And you need to continue to keep in contact with friend of the court of different things come up, they may be able to direct you or help you or indicate at least in their files that you have contacted, that you've sent what you could this month, that you're in flux or whatever have you, so that we can try to avoid this particular process again.
I've not done that either, and I apologize for that.
All right. So with that, again, like I said, our bond, you'll be getting out on that. Well, let's say it like this, our bond will be at this point upon the payment of the $1,200, you can be released.
Oh,
All right.
much. Thank you.
You are welcome. However, you still owe, unless and until you get a review done, you still owe the 611 every month.
Yes, ma'am.
So make sure you either, there's a couple of things you can do. If you're making that kind of money where you can pay that, then pay it. If you're not, pay what you have, but then make a request to have your case reviewed based upon the money that that you're making at this point. If it's not the same as it was before, then maybe you might be entitled to get it reduced, but they need to know that. They have to do a review and do all of that, but you have to file the paperwork because nobody is going to do it for you.
I appreciate that. For a while, I'd like to make double payments because I would like the amount to go down.
I want to make something clear. They don't pay the mother for his 20 searches. All they do is not put him in jail. But his arrears continue to grow. His payment history still shows as 0, but he is not held in contempt for willfully not paying. They consider it not a willful violation if he jumps over through these hoops, basically. And so it's frustrating, but I've said this before 100 times. If the courts and the government think that child support is so important that they're willing to put all this money into this, because we realize that right here on the screen is enough money to cover most of the payments in about a half hour or whatever that we see, they should put their money where their mouth is and pay ahead of time and follow up with him afterwards. They'll make people wait till people die before they get or retire before they get child support payments. Well, the government should be paying that up front and collecting for them if they think that child support is so important. They don't. Don't let them fool you. They don't. This is a process that they like to be involved in. It's again, put your money where your mouth is, government. And yeah, Paisley's a communist, but I am very generous with tax money because I know what tax money actually goes to. I've worked in government. Let me tell you, believe me, I could fix a few fucking problems. Believe me.
Very significant.
Yeah, that's a lot of amount.
Yes, ma'am, I know.
Okay, so if you don't make the payment, then Mr. Bosky, he, upon a month after missing it and you don't receive either the 20 job searches or lack of payment, then a benchmark can automatically issue without you having to come back and ask for it.
Oh, that sounds great to me.
All right. I saw that you had, Mr. Bosky, I saw that you had your hand up. Was there something else that you wanted to request?
Right, and I just wanted your permission as well as Mr. Kearns. I was given his brother's name and phone number. I can reach out to his brother to assist on that payment online to expedite that payment. Typically speaking, usually with a contempt, there's an amount and number of days. Do you have a preference in days? I'm hoping that after this hearing, I'll reach out to his brother and get this expedited exponentially for you.
Awesome. Well, sir, yes.
He's ready.
Again, I do not believe in people just sitting there. So I'm saying 2 weeks. If brother is not able to come up with it or whatever, you'll be our guest for 2 weeks. But then after that, then I expect him to be released.
Correct, ma'am.
Thank you. He's ready to send it now. Sir, if you would reach out to him,
as soon as we're done here, sir. Yes.
I appreciate it very much.
All right.
Thank you, Your Honor.
Did I cover everything now?
Yes, you did, Your Honor. Thank you very much.
All right. Thank you.
Thank you
All
for
right,
that.
sir. Good luck to you.
Thank you.
You're welcome.
Joseph
If you
Allen
can believe
Stocker,
it,
Mr.
this
Stocker
guy
has one
is
case.
going to be even more annoying than the last guy. How's that possible, Paisley? How can that be? Oh, it's possible, ladies and gentlemen. Buckle the fuck up, because this guy is even worse. Also, I think we do need to do like a mandatory check-in about Cody up in the top middle here with what I can only describe as a Western style going on today. Red is a bold color. I like it. Bold. I want some more deep red. That's like a Christmas color to me, but I like it. This judge is so, like, demure. Polite. What is the meme? Somebody else fill it in. Somebody knows what I'm talking about.
At our office. The docket number is 2019-00157 547 DS Joseph Stocker versus Melanie Thornton. The case is actively charging at $384 per month for the support of one minor child. That child is not due to emancipate until April of 2020 or 2031. He has an outstanding arrears balance of $25,682. Since the inception of the case, we've had no payments applied whatsoever by Mr. Stocker. There's only been one show cause, one bench warrant being issued. Again, no payments being applied. I did have an opportunity this morning to speak with Mr. Stocker. He informs me that he resides in Ohio. He was living with his parents, not paying any rent. He claimed that he is recently homeless. I'm not sure to what extent. I asked him if he was staying at a shelter, living outside, or bouncing around between friends and family. He didn't really give me a clear answer. He has just this one child, a high school education. He didn't really have much in regards to assets, vehicles, or even available resources. He is on Medicaid. He claimed that he's recently had some kidney stone issues on the 7th of this month. He's not on probation or parole, but he has one prior felony. The issue that arises with this case, Your Honor, is that we've had limited to no contact with Joseph. The custodial parent had contacted our office June 22nd of 2023, advising that Joseph informed her that his plan is to never seek employment and never to
Vince
pay
is
on
gay,
this.
Kevin. He's allowed. We vetted him. He's allowed to say a gay. I don't know why I think that's so fucking funny.
Case. He also wanted to see the judge today so that the judge can sign off his rights to this child. Thank you.
All right, thank you. Mr.
Our office June 22nd of 2023, advising that Joseph informed her that his plan is to never seek employment and never to pay on this case. He also wanted to see the judge today so that the judge can sign off his rights to this child. Thank you.
All right, thank you.
I'm not sure that we all heard that. One more time. For the record, you asshole. What a stupid... I love it when they're so stupid.
At our office June 22nd of 2023, advising that Joseph informed her that his plan is to never seek employment and never to pay on this case. He also wanted to see the judge today so that the judge can sign off his rights to this child. Thank you.
All right, thank you. Mr. Walker?
Yes, Your Honor. I did have a discussion with Joseph about this case. We had a discussion about rights and job searches and stuff like that. He indicated that he isn't currently working. He does not have the resources to make a payment in this matter. I would ask the court to withhold a contempt citation. He has no available resources to make any sort of payment. However, he is indicated that he is willing to look for work and get a job and start making payments. However, that's, he's got to get out to do that, right? And he is concerned about this case growing and the arrearage is growing. So he would like the court, or is interested in signing off his parental rights if that's the case, to stop the potential accruing of arrearages. But he does understand that may or may not be not likely to happen today. We're just here for this contempt hearing. Thank you.
All right, thank you. All right, sir, Mr. Stocker, now it's your opportunity. If there's something that you would like to tell the court regarding the situation, you may do so at this time.
I am just struggling with the payments, and I just think it'd be better. Plus, I don't really get to see my son. She don't let me see visits with him. We don't talk. She changed her number, and it's just been an emotional spiral. And it's just, and I'm sorry for being in front of you today. But
All right. Okay, so sir, let me just let you know something, a couple of things. One, parenting time, that's time you get to be with your son, spend time with your son. That's a separate issue from the support issue, but it is something that you could also contact the court about. You have to file a motion regarding parenting time and then come forward for the hearing and stuff like that. But you have to make some effort because nobody's going to come after you. And just because the mom isn't cooperating doesn't mean that you don't have the ability to come to court to still establish a routine whereby the court can make her follow that routine. But until something is in place, that won't happen. But that's a separate issue from the money issue. And today is the money issue. With respect to the money issue, there's no termination I could do at a support contempt proceeding. I can't do it like that. It doesn't happen like that. Your rights and obligations and things like that are not, or cannot be handled in this type of setting. Nor is it the simple process that you think it is. And it has some other significant legal consequences that you might want to talk to an attorney about before you honestly willingly go and do something like that. But with respect to what you owe today, it sounds like to me that you really have had very limited contact with the friend of the courts. I'm not sure if you were aware of the fact that if you don't have resources and you are looking for work, you can send in 20 job searches in lieu of making a payment. But you have to do that for each and every payment that you would owe. You would have to send in those 20 job searches. It's not automatic. So otherwise, those payments will still be adding.
I operate best poolside, Kevin. In fact, I did some pool, what would we call them? Pool lives when I was in I didn't go to California last year. When I was in Florida last year, I think I appeared from a couple pools. There's a lot of video. Deep, extremely deep catalog of content. Or cock, if you will. Extremely deep catalog of content.
Yeah, but at least if you got the 20 job searches in, you won't be brought in on this type of process. I understand. The other that with you having no resources, I can't say that then, I'm not sure if you knew you could do 20 job searches, and it doesn't sound like to me you have any resources that you could have made payments from. So I'm gonna hold off on contempt this time, because if this case comes back to me, then I know that I told you about the 20 job searches as a alternative to making a payment. But since I don't know if you knew that coming into court today, I'm gonna give you that benefit of the doubt, all right? So I'm not holding you in contempt. Again, I'm not, since you have no resources, I'm not gonna hold you in custody, on our warrant as well. However, when you are released, you still have these monthly payments that are going on. If you cannot make the payment, you have to submit 20 job searches. If you don't do that, then I'll give you a month grace period to try to find a job and earn some income so that you can send some money in. Because I know you have to, for most jobs, you have to work about 2 weeks in the hole before you get your first paycheck. After that, though, if you have not sent in your 20 job searches or have not sent in the payment, then I'm going to say that the front of the court can do an automatic bench warrant at that point. So don't let it get to that point, okay? So you're getting released on today on our bond. If there's something else that is holding you, then I can't control that. But at least as far as this case is concerned, this is not going to hold you. I would suggest that it sounds to me like you really would like to be involved in this kid's life. You have to make some effort, sir. You have to file a motion and do all of that stuff. I do it for guys all the time. And so don't believe the hype that, oh, the court doesn't honor father's rights and things like that. I do all the time. You have to make the effort to file a motion and to come in so that I can do those things.
Okay.
Understand?
Yes, but how you do those application things?
Well, you live in Ohio, right?
Right.
So, but you in our jail. So before you go back to Ohio, come on down to the courthouse. We have something on the 5th floor called the Legal Resource Center. And go in there and get forms. If you can't get it from there, you might have to go over to the front of the court to get them that you would need in order to do the 20 job searches. But if you wanted to follow up on the motion regarding parenting time, you have to get the form from our clerk's office.
I'm a millennial too, but I'm a cuspy millennial, and so that means that I have to look up to see if I'm a millennial. But I was born in 1988, and apparently that is smack dab right in there as a millennial. You know it, always. Who doesn't love a little Huck Tua? But I love all the generations here. We have a lot of fun. But we do trauma bond a lot. That's okay. We've all been through some shit. You know it. You know it. Tin Man, I don't know it. I think you're Generation X. Is the one before me X and then Millennium? I think. See, I don't, this is the thing. I have to ask my overlord Google and YouTube Daddy. Google Daddy. Google Big Daddy. Google Big Papa. We should call it Google Papa. YouTube Daddy. Yeah. We know the ranks.
Otherwise, you would have to go down to 82 Ionia to get the forms for the front of the court. Okay, and that's before you go back to Ohio, so you have it. Okay?
Thank you.
You're welcome. Questions, issues, concerns?
It just
Your
got,
Honor, I think we're all set at this end. I
I have
appreciate it.
nothing, Your Honor.
All right. That's music to my ears, so thank you very
Sure.
much.
thank you.
Seeing you guys, sir.
I'm not sure who that would be music to anybody's ears. A little crazy. What were we gonna watch next? I put it all in a folder and now it doesn't make any sense. Ain't that the truth? Oh, this one. Okay. MB, you still here? This might be up your alley. But I recorded it in 1.5 speed. So if this is too fast, let me know, because I can change it now down, but it might like fuck up the voices a little bit. They might be a bit robotic, you know, Judge Meacham. So anyways, this case, there's some pretty dramatic photos in this case, I will say that, but the question I have we will talk about at the end. You'll see what I mean, but yeah, let's see.
We're going on to YouTube now to comply with the open courts provision of the Texas Constitution. I have 2 cases set. I'm going to ask you if you're all here on that case, if you're ready to go, and if you need a record. So the first case I have is Gibbs versus Circuit of the Americas. Who's here? How long is your case? And do you need a record?
Judge, this is Matt. Doesn't that matter here?
Are y'all all having, hold on, are y'all having problems too? Is everybody having problems with his feed?
Yes.
Okay. You're very delayed, Mr. McMullen. Let me try again. Maybe it corrected itself. I don't think so.
You are very delayed, Mr. McMullen. You're stupid. Your mom doesn't love you. You're delayed. I don't know why that was so funny to me, but seriously, you're delayed. It sounds like a real insult.
I think your connection's not great. Try again. You're Mr. McMullen.
Yes, Your Honor, this is Mr. McMullen. I'm here with my co-counsel, Leslie Bearden. Is that any better?
That's much better.
Excellent. I do see my opposing counsel, Ms. Anna Dodds, on this hearing as well, and I think 20 to 30 minutes is, I would say 20 minutes. The last time I said 20 minutes, it was 30. So 30 minutes should be very safe.
Okay. And it's a motion to compel?
That's correct, Judge.
Do you need a record or do you not need a record?
Yes, please, Judge.
Okay, thank you. And then Ms. Dodds, do you agree with that?
I do, Your Honor, thank you. I think we could do it a little shorter than 30, but we'll see, like Mr. McMullen said.
Okay, and then Ms. Duet, if you could start getting set up for a record on that one. And then Moon versus Chavez.
Hold on, did she just say that the court reporter's name is Duet? And she is making a record? I love it. It's like poetry. It writes itself. She's a duet doing a duet by making a record. I love it. I love it. Also, this is 1.5 speed. If you're watching this in the future and you're having a trouble with it, because let's face it, your ADHD may not be as rampant as mine. If you watch this later or whatever, you can slow it down to 0.75 and it should slow it down, but it'll slow me down too. And I'm warning you, that might be creepy. Okay.
At all. Who's here on that case?
Good afternoon, Your Honor. My name is Jamel Thomas. I'm here for the plaintiff.
Your Honor, I'm Christian Davila. I'm here for defendant Alicia Belen Moreno.
And is there the other defendants that are listed, is this a motion that also pertains to them, or is the motion just regarding the Moreno defendant?
Our motion, Your Honor, is a no evidence motion for summary judgment, only specifically for our insured defendant Moreno.
And Your Honor, I said plaintiff because Courtney Moon settled out of the case. We just now currently are here on behalf of Ione Moon, the minor.
Thank you. Okay. Are there lawyers here for Chavez and Guzman or no?
I don't believe so, Your Honor.
I don't know that I expect them to be. I was just asking if they were. And y'all don't need a record because it's a summary judgment, right?
Correct, Your Honor.
Okay. All right. Well, let me get the record case just because it's set first. I'll do that one first and then I'll do the summary judgment after that. But it shouldn't be too long. If y'all want to go off screen, that's fine.
Great. Thank you, Judge.
Okay.
Ready, Judge.
Thank you. Going on the record, this is GN-21-5.
Okay. This answers, because honestly, I'm not going to lie here, MB. I thought it said Circus of America. I was picturing a circus, a very large circus. Circuit of America maybe makes more sense. I didn't research this case at all, but I did hear them talk about that. I'm not joking. I really did my, benefit, my whatever analysis my fucking weird little brain does, and it was like, it's circus. Obviously, it's the circus, Paisley. This is in Texas. It's the circus. Okay? But I just want to prepare everybody that we are getting a PowerPoint. And that's right. We're going to watch it on 1.5 speed. What you wish you could do at your boring-ass jobs. Hey, if you don't have a boring job and you love it, tell me about it. But Most of you that sit through PowerPoint presentations really wish you could speed that shit up. And today we get to do that.
511, Gibbs et al. Versus Circuit of the Americas et al. Let me take the attorney announcements for the record.
Good afternoon, Judge. This is Matthew McMullen and Leslie Bearden on behalf of the plaintiffs, the Gibbs plaintiffs.
And for the defendant?
Hannah Dodds on behalf of Circuit of the Americas.
There are also some other defendants listed. Are there any counsel here for them? Are they still part of the case?
They are
Judge, go ahead.
no, they're in the process.
Try again.
That matter has. I'll take a lead if that doesn't, if Ann doesn't mind. The S3 party and there's another set of Gibbs defendants that those two matters have settled, and the Savage, I think it's listed as potentially Nelson on the pleadings. In any event, all of the parties other than the two parties here before the court have resolved their issues, and so the remaining the paperwork between those parties is sort of circulating, and so we do anticipate a dismissal would be forthcoming. But presently, only the Gibbs plaintiffs that I represent and the Circuit of the Americas defendant that Ms. Dodds represents are active parties in the case.
Thank you. All right, well, proceed on your motion to compel. I guess first let me know, have you sent anything in the box that I need to review for the hearing?
Judge, there is our motion paperwork, and I believe there's a single deposition again. I do have a PowerPoint this afternoon, which encapsulates the actual, this is a motion that deals with literally a single email. And so it's not a
You heard that correctly, ladies and gentlemen. This is a PowerPoint presentation, many multiples of pages for what is a single email that they are fighting over in discovery. So this is not a divorce case, in case you didn't get that yet. We jump around here, and this is about an email. And I think it's an interesting legal sort of question. Also, we need to talk about Della Duet. First of all, Della Duet with 2 T's is that woman's name. That is a star. That name is the name of a fucking country star. Della Duet, ladies and gentlemen, gracing the stage, singing court tunes. I don't know. Seriously, Della Duet. And her background is drums? A water dispenser? Is it real? Is it her? It looks like an image to me, but I can't understand why that would be the image picked. But, oh, Della Duet, the drummer. She's a drummer. Della Duet, her dog's moving on the couch. That's her real house. Even more epic. She has drums in the living room. Nuts. I love it. Like, in what room in your house do you have both a office-size water dispenser and a full drum kit? I'd love to see the pictures of that.
terribly deep record, and my PowerPoint does show the court where the issue is.
All right, well then go ahead and lay out your motion, and you can, I think I gave you the ability to share your PowerPoint, and then we'll hear from Ms. Dodds when you're finished.
Thank you, Judge. Judge, this is, as I indicated, this is a simple, relatively simple motion to compel a single email. My understanding is that Circuit of the Americas objection on this motion is none other than the relevance objection. We are not here on a burden of production. As I said, it's a single email. We're not here to discuss the expense of production. It's not privileged. It's not a trade secrets matter. And my understanding is that Circuit of the Americas would not like to produce this email because of the timing of which it was sent. We'll get into that in a little more detail, but just for the court's background, this is essentially a premises matter with some correlating negligence claims. My client is Mr. James Gibbs and his family. Mr. Gibbs was a part of a contracted crew which was working on the Circuit of the Americas premises for a period of about 9 weeks prior to the incident that gave rise to this suit. The mechanism of injury came out from a what we're calling a pull gate, which I'll show in a moment, which was left unsecured and was jutting out into the roadway. Prior to the incident, for about 8 or 9 weeks, that gate had been left open on the left side, and Mr. Gibbs' understanding was that he was to enter on that side. On the day in question, the gate was left unsecured, jutting out into the roadway, and we allege would not have been visible to Mr. Gibbs. The police report confirms that at that.
So I just want to interrupt his PowerPoint presentation with my own PowerPoint presentation, saying this is actually going to be quite jarring. These photos are fucked up when you see them. Just prepare yourself. I was a little taken aback. Taken aback.
At least the police investigation would reveal that the angle of the pole gate, as it was on that date, would have made it invisible to Mr. Gibbs. These are the photographs from the scene on that date, which show the aftermath. And so the question.
Look at that. That's fucking nuts. Holy shit. Like, I can't really tell if the person's alive or not based on what they're saying, but that is a huge gate. I don't think that's gonna buff out. I'm gonna be honest with you guys. I don't think that's gonna buff out. I could be wrong. I've been wrong before, but I don't think it's buffing out. So evidently this was not right in front of the person, Wahoo. It was basically left to the wind to blow to a point where they couldn't see it until it was like going through the car. Because, I mean, to be honest, who would drive into that if they saw it? You wouldn't. It's just so dangerous. You wouldn't put yourself at risk like that. So I understand that, but that's their legal claim. And that's what this whole email sort of surrounds itself with. Basically, okay, so if we go back to the police report, I'm going to back it up here for a minute. Oh, here we go. Back. Oh, fuck. Here it is. So look, this basically says, I could read it. Hold on. Unit 1 was a vehicle with 3 occupants. The driver turned into the private drive of the address. The driver pulled behind another vehicle who was stopped, waiting for the entrance gates to open. I have to go closer to it. I'm really getting old. The gates consist of 2 large metal bars that fold from the edge of the roadway to the center of the road. The bars are approximately 30 to 40 feet long, 10 to 12 inches wide, painted red with reflective tape along the length of the bars. The bar on the right side of the road was leaving the point. Oh, the bar on the right side of the road was closed all the way. The bar on the left side was slightly open, leaving the point or edge of the bar open at an angle of approximately. Bar or gate would not be visible if finding it directly, as the tape is only on the sides. Oh, so they didn't have tape all over it, is what they're saying. And then it says the driver then proceeded to try and enter through the open part of the gate, resulting in the edge of the gate bar to penetrate the cab of the vehicle. The edge of the gate bar struck the back right passenger in the head, causing, oh God, catastrophic and fatal injuries. Oh, fuck. The driver was also critically injured, and the front passenger was not injured. God damn it, Paisley, you should read these first. Terrible. Terrible. Could you hear me? I think you guys could hear me. That's awful. So again, you can see the reflective tape over here, but you also, why would they put it like that? It's so weird. Short-sighted. Like, why wouldn't that be rounding it so that every angle would be covered? It's so simple. I mean, screams negligence to me if the gate wasn't secured, but I don't know anything about this situation. I didn't read that earlier. I saw these pictures. I was sort of horrified by them, but you'll see what legally I'm interested in as we go forward.
This poll gate so that we have liability for the jury. And we, among other things, need to show as plaintiffs control over the premises. We can do that, and the law affords us the ability to do that many different ways. But just as an example, we can do that by way of showing things like remedial measures. Remedial measures are obviously an event that takes place after the fact of an incident. The email that is in question, and my understanding is that the core of the objection raised by Circuit of the Americas is that this email was sent 21 months after the event of our incident. And we'll talk a little bit more about the substance, what we understand the substance to be. But if we're taking it just on the timing, I have no authority, I've found no authority, and Circuit of the Americas has presented no authority that just the timing of this being 21 months after the incident is insufficient. The Cohen case, which is Cohen v. Landry's Inc., it's a Houston Court of Appeals matter, which was where petition was denied. It's 442 SW3D 818. We've cited to 825 there. Evidence of subsequent remedial measures is admissible to prove that the defendant exercised control of the premises. And as I'll discuss in a moment, when in that case, we're talking about admissibility for trial. At this stage, we're not even at admissibility. Defense has argued they don't have to provide it even in the discovery context. So before I leave the Cohen case, it's clear under the case law that subsequent remedial measures and other subsequent activity can certainly be relevant to the question of things like control in a premises case, which is what we have here. Our email is a single email. It was drafted by the Circuit of the Americas Director of Safety and Security, sent to the S3 security company. S3 has been settled out of this case, and I imagine that Circuit of the Americas will argue to at least some extent that S3 was in control of the premises. So then the question becomes, to what extent are they managing and controlling this premises together? That's where emails come into play. In this case, we have an email where Hunter Webb, the Circuit of the Americas Director of Safety and Security, was asked about the extent of his communications with S3 security. What he responded with is that there are a couple of emails involving escalations to S3 security regarding the same gate that's at issue in our case.
So, Sherry, what it sounds like is there were multiple different levels of people responsible in this accident, and in the course of their dealings with the other security company, who is now settled out of this case, they revealed an email that we're going to read here in a moment, and what this guy's asking for is, I guess, any responses in regards to this email. And I do understand, MB, what you're talking about here, where, so her whole comment says, if a defendant fixes something dangerous, it can't be used as evidence of liability. The goal is to encourage fixing problems. However, MB, this email was sent before the accident, and I think personally, I think that any responses to it would be relevant and should be accessible for discovery. We'll see. This is why I'm glad you're here, because I wanted to talk to you about it.
Here we see in the Hunter Webb deposition, he's testified that he has escalated in the past issues to Candace. Candace is the owner of S3 Security, and that in fact one of the times he did this, it was by email, and it was after the incident. The reason I highlight that it was after the incident is there's another email referenced in this exchange in the deposition transcript, which we do have, and it shows just how relevant these types of emails are. This is one of the emails referenced. This actually occurred 1 month prior to the incident. Our incident happened on August 14th of 2021. On July 14th of 2021, 1 month prior to the accident,
Hold on, I'm just doing some live prevention of anybody talking to these people. It says, we need to make sure the red poll gates are secured when they are in the open position. The wind gusts can move them out into the traffic lanes, creating a huge risk for us should someone hit it. And they already have this one. I don't know why they won't just give over, why they wouldn't just bury this in amongst all the rest of the shit that they were supposed to send them. It seems like that would have been the message from me.
Security America's manager of safety and compliance is warning S3 Security that they need to make sure these poll gates are secured when they are in the open position because they can move out into traffic lanes, which creates a huge risk should someone hit it. So we want the counterpart to this, which is what was said after the August 14th incident. The standard raised in Circuit of the Americas brief on this point conflates, I believe, the relevance standard with a relevance for trial standard. We're at the discovery stage on this motion. And relevance is, as the Texas Supreme Court has made clear, is a broad standard. We're looking at a broad definition of.
Also, Hector, yes, I know that the thing is cut off. I'm working on it. Today is first launch of this, and I'm trying to make it bigger, but I can't do it live. I don't have guys in the truck. I have guys I'd like to fuck. Guys? But no guys in the truck.
Relevance here. It's relevant to the subject matter. So Circuit of the Americas has not argued otherwise, and if they have, I haven't seen that argument, that there is no relevance on the subject matter or that the parties are irrelevant. They also haven't argued that we shouldn't see this email because it relates to work product or something that was prepared in anticipation of litigation. It is relevant. My understanding of Circuit of the Americas argument is just that it happened after the incident, and I simply have not found any authority that withholding a single email because it happened after the incident, even if it was 21 months after the incident, where every other factor aligns in our favor, is not a basis for discoverability. As a practical matter, Judge, if Circuit of the Americas is concerned about the relevance of this email, it can be discovered, and then we can see what it says. For example, we actually don't know from any other part in our record that this email is in fact 21 months after the incident. I'm just taking counsel's characterization of it as being that late, but we don't know because we haven't seen it anywhere else in the record, and Mr. Hunter Webb did not testify to that. So, Judge, we believe that it is.
Okay, that sounds great.
That's
That's great. So that's the motion. You laid it out very well. Ms. Dodds, response.
Good afternoon, Your Honor. I know the court does not prefer to hear discovery disputes. This is the first one we've brought before the court, and I agree with Mr. McMullen, it's very narrow. I don't believe we've misconstrued the discovery guidelines provided by the Texas Rules of Civil Procedure. They start first, as you well know, only relevant evidence is discoverable. Despite asking multiple times, I don't believe we've heard a reason for plaintiffs, and it's their burden to carry as to which fact of consequence this email tends to prove. I'm happy to tender it for in-camera review as to the.
I don't understand why they're arguing this. I don't understand. Also, it's on 1.5 speed, which is why it's so fast. This is the speed that my brain works at. Seems like such a weird argument to me, but here's the thing. So she's saying, I'll give it to you for in-camera review, which means just the judge, not on the record. But it's weird. It's weird.
21 months after the date of the incident. But the fact of the matter is, this is the premises liability case. The jury is going to be deciding whether this is an unreasonably dangerous condition of which CODA had, or Circuit of the Americas had, actual or constructive knowledge on the date of the incident. And an email 21 months after the fact does not tend to make those issues more or less likely. I think it's also a motion for sanctions. So for the record, I'd like to address it. I think the way the discovery process has worked here is the way it's intended to. An email came up in deposition. It was requested by plaintiffs. We located it, advised as to the date of the email, the fact that the email exists, and provided our objection. And now we're here today for the court to rule on this narrow issue. it's plaintiff's burden first to show the relevance. If the court agrees that the email is not relevant to a fact of consequence, it's not discoverable. If the court believes it is relevant, then plaintiffs have to show that it's admissible or reasonably calculated to lead to the discovery of admissible evidence. We heard a little bit about subsequent remedial measures. That only comes into play if those facts are disputed. I guess that remains to be seen, but I think we stop at the first step because an email 21 months after the fact doesn't speak to the dangerous condition on the day of the incident or what Code knew or should have known about that condition.
Okay, well, I think this is pretty simple because it is so narrow. I think that why don't you just send it to me for an in-camera review? You can do it however. I don't know if it's easier to send it by messenger and just drop it off at the district judge's office. And then y'all can both send me proposed orders and I'll rule based on that. But the other way to do it, is to basically send it by courier, which we don't do that much anymore. But that way you can copy Mr. McMullen and show you copied him, just with the top letter, and just the sealed portion, the sealed envelope is just what gets delivered to the district judge's office.
So this is the part I don't understand. She's asking for her to basically send over by courier this document and CC the other lawyer, but she's not giving him the email. So it's not a carbon copy, which is what CC stands for. So to me, that would be ex parte. A cover letter. I know, but what I don't understand how making it, like putting it on a cover letter and sending it by courier allows the ex parte communication. In-camera reviews allowed by the rules. So even though it's basically a fully fucking ex parte, just between her and the judge, I would be so mad. But I guess, I don't know, that was my main question. Like, how is that not... Like, I guess if they were in person, they would just walk over and hand it to the judge. The judge would look at it and then order if it's discoverable or not. And so in the courtroom, it may not be so underhanded seeming, it seems to me. Like, it just seems very odd. But I guess the cover letter sort of exempts them from that ex parte-ness. Like, hey, remember she told me to send this to her? I'm sending it to her, is basically what that means. And as an officer of the court, you have to trust that the judge will properly rule and that they will produce the right thing. Because we all know lawyers are completely trustworthy all the time. Although, honestly, your job hinges on it. So there's this fine line. You can't be lying to the courts. We've heard this. We know this. It's just hard for me to understand sometimes. Brother counsel does not look happy about it. Let's put it that way. Brother counsel. Remember yesterday? Ugh.
And then it's documented. I think that's easier to do than do it by email. You could also do it by email, but it would be an ex parte communication because you can't send me a copy without sending him a copy too, I think. So
absolutely. We'll do a physical copy by courier. And
okay. Can you do that by tomorrow?
So why, but here, I don't understand it. What I don't understand is why by email it's ex parte, but by courier it's not. That seems like a rule presented by the courier lobby, who has been running out of fucking shit to run around for a long time since email came around and DocuSign. And so they were like, oh, we got to get to this judge. They bought a judge. They bought a judge in one county. Allegedly, it's obviously a joke. Because the email wouldn't include the document. I know. They could password protect it and only tell the judge the password, MB. There's a workaround. but then the password would be the ex parte communication. But ostensibly, it's the exact same.
Or do you need another day? You can do it by tomorrow at 5.
Absolutely, we can do that.
Okay, so I'll look at it. It shouldn't take long, Mr. McMullen, and I'll rule and give a ruling after that. And I'll look at your proposed orders and make a decision. Okay, thank you. Let's go off the record. Y'all are excused.
Thank you.
Let's go off the record. Y'all are excused, she said. I just thought it was an interesting case. Terribly sad. I definitely didn't look at it and realize that they passed away. I mentioned it, but I didn't do my research. I put Christian back up on the screen for you guys. Their case was weird too, but I did not record it. Sorry. I did record this one. Judge Amy Clark Meacham. I think it's pretty good. I think that, I just thought it was an interesting sort of legal predicament that they found themselves in. I also wonder why on earth they would argue doing that and not just provide it. But, you know, somebody on their legal department talked with Anna. They were talking about it one late evening while working on the file. I don't know. I guess. Anyways, I hope that you guys had a wonderful night tonight. I did. Yeah, the insurance company is representing the defendant for sure. I would believe that. Thank you again for being here. Thank you for hanging out, you know. It was great. I had a really fun time. Thank you for all the feedback on the this motherfucker down here, which will be getting better and better and better as we go. I'll work on figuring out how the bottom works. That's what he said. Anyways, no, seriously, I hope that you guys have a wonderful evening. Please remember that I love you. I am proud of you, and I will see you tomorrow. Maybe Nico variable. It's what is it? A browser extension that I'm using, so I'll have to work on it. Anyways, I love you. I'm proud of you. I'll see you in the next video tomorrow. Bye. I said bye.
Ways down and